She was ordered deported. Her marriage had collapsed, her green card was gone, and immigration wanted her out of the country for good. Today, she's about to get that green card back. My client is about to get her green card back. She first adjusted status through marriage, went through the conditional green card process, and then ended up in removal proceedings. Now she is out of removal proceedings and waiting for her green card. People, this is story time. This is a very common fact pattern, a very common situation that is happening right now in immigration. Let's dive into it. My client came here on a student visa and was doing extremely well for herself. Extremely well, very bright. She decides that she wants to get married, of course. All right. Amazing husband, amazing reviews. Everything was great. She graduated, right? She was doing her master's. Somehow the marriage started to become a little shaky, right? But now it was time for her to remove the conditions, right? Keep in mind, the first interview was waived. So usually with waived interviews, a lot of those were happening during the Biden administration. The interview was waived. So she was fine. She now needed her husband to do the joint removal of conditions. Guess what? She graduated and got multiple job offers. The man said no, he was not going to do the joint removal of conditions. But he also allegedly held on to a lot of the joint evidence for her, to prove that they were in a bona fide marriage. She believed she was in a bona fide marriage. But the man was gone as soon as she started getting all these job offers. Anyways, I digress. She was not able to prove that she tried to do a good faith waiver, right? We tried to do a good faith waiver for her, but we just did not have the right amount of evidence. She did not have everything. She had nothing. The husband took everything in terms of the evidence for us to prove that the marriage was bona fide and legitimate. Within 6 months, we got a notice to appear, right? She is now in removal proceedings. Keep in mind, educated, got her master's, multiple job offers. Now she is in deportation proceedings. She cannot accept these job offers, people. Devastation. Devastation. Been to the office, trauma. But this is what we deal with. Anyways, we now had to prove to the judge, right? We now had to prove to the judge that, listen, she was in a good faith marriage. Here is the evidence. She entered into it because she was in love. The judge denied it. The judge denied it. And now we have a removal order because, people, we just did not have enough evidence. But something happened because, mind you, this case is not 1 year old or 2 years old, right? It is 3.5 years old. During the whole separation and everything and her divorce, she was able to reconnect with an old partner who was in the same master's program as her. They decided that they were going to get married. I was a little bit against it because any case that is in deportation proceedings has a presumption of marriage fraud, right? She actually had to, before I took the case any further, she had to convince me and my team that she was in a bona fide marriage, right? The husband came, they bought assets together, they did all sorts of things together and had a super strong case. So, we were able to refile an I-130. There was an I-130 interview, and we were prepared. And because there were 2 educated people and they had the evidence to prove it, we were able to get that I-130 approved. Once we got the I-130 approved, we were able to file a motion to reopen, because there is a deportation order against her and she was ordered to leave. She did not leave. The motion to reopen was granted, right? We presented everything with the I-130 to the court, but we also hit them with a motion to terminate the removal proceedings, people. Motion to terminate, and I almost fell off the chair. And the motion to terminate the removal proceeding was granted. Hallelujah! It was granted, and we filed the I-485. They did their interview, and the officer said that he would approve the case. People, you have no idea how long this case took, how many battles this case took, but it ended with a good result. So, adjustment of status through marriage while you are in removal proceedings, or even if it is a removal of conditions case in removal proceedings, is extremely common and more common than you think. But just because you are in deportation proceedings, it does not mean that you are going to get deported. If you are in deportation proceedings and you do have a bona fide marriage that you are in, you can still file that I-130. But what I have realized is that if you are in deportation proceedings and you are filing an I-130, you must do an I-130 interview before they approve it. And mind you, if you get married while you are in deportation proceedings, there is an assumption, there is a presumption of marriage fraud that you have to overcome. The good thing is that once you beat that interview and overcome that interview and it gets approved, you are able to move that case forward within immigration court. And a lot of times, as previously mentioned, you can do a motion to terminate the removal proceedings so that your case can actually go back to USCIS for regular processing. Yes, you will have to do an interview again for your I-485, but at least you do not have the fear of deportation. The same thing applies if your removal of conditions got denied, right? Even before you entered into deportation proceedings, you do have a second bite at the apple to actually prove to USCIS that you did enter into a good faith marriage or that you are eligible for one of the waivers, right? You can still prove to the court, with or without your spouse, that you are entitled to remove your conditions. It can be if you believe that you were abused, if you believe that you or your U.S. citizen immediate relative will suffer significant or extreme hardship if you go back to your home country. But most importantly, it is proving that you were in a good faith marriage, so just because you are in removal proceedings, it does not mean that you cannot get married, does not mean that you cannot redo your removal of conditions, and does not mean that you cannot get out of removal proceedings. You can terminate your case through a motion and through proper arguing of that motion in front of the immigration judge. I hope this helps. If this was helpful, like, share, and subscribe for more story times.